Welcome aboard, applicants. We're going to be talking about and reviewing contract law. Let's get going. Our contract shopping list begins with formation. It then goes to third-party rights. It then proceeds to conditions, which can be broken up into express conditions and constructive conditions. There's also a discharge of the duty to perform. This is why we have the word performance here. There's breach of contract issues, and we follow all that up with remedies. Again, formation, third-party rights, conditions, discharge of the duty to perform, breach of contract, and remedies is our shopping list for contract law. Let's break all of these areas out and talk about them. Formation. Formation in contracts begins with the applicable law. We look to see whether a law is governed by the common law, in which case the contract would concern services, or a contract concerning services, a contract concerning the sale of an interest in land, or the contracts concerning intellectual property. Now we ask ourselves, if that's not there, is the contract governed by the Uniform Commercial Code? The Uniform Commercial Code governs contracts for the sale of goods. Goods, by definition, are tangible personal property readily identifiable at the time of contract formation or at the time of identification in the contract. So again, to recap that, common law contracts, generally services, and generally the sale of an interest in land. Uniform Commercial Code contracts, contracts concerning goods. Goods by definition are tangible, movable, personal property, readily identifiable at the time of contract formation. If we can't make up our mind, then we have to go to the predominant factor test, and we establish what law, common law or the Uniform Commercial Code, predominates the contract, and we would generally go with that law. If the UCC governs our contract, we have an additional consideration in this particular stage, and that would be establishing whether the parties are merchants. And remember, merchant status holds that party up to a higher standard of good faith and fair dealing and commercial reasonableness. But a merchant, by definition, is one who deals regularly in the goods of the kind involved in the contract, or who holds themselves out as having special skill or knowledge related to said goods. Again, merchants are those who regularly deal in the goods involved in the contract, or who holds themselves out as having special skill or knowledge related to said goods. After establishing merchant status of the parties, we then proceed to contract formation proper, which is where we look to see if we have a validly enforceable contract situation. Now, a validly enforceable contract situation is a special situation. It's the situation where all of what we will be talking about has already been established. And in these special situations, I would take just a moment here to explain to you that you would talk about mutual assent, consideration, and the statute of frauds defense. Otherwise, what an applicant would do is go through what we're going to be talking about right now: establishing offer, acceptance, consideration, and the applicable defenses. Contract formation, a validly enforceable contract, is defined as having legally enforceable offer, acceptance, consideration without any applicable defenses to contract formation. An offer now, by definition, is a present manifestation of an intent to be bound containing certain indefinite terms communicated to an identified offeree. Looking into offer now, an intent to be bound is measured by an objective standard. That objective standard in whose position? The offeror or the offeree? It would be the offeree. It's in the offeree's position that we look to see, would a reasonable person in the offeree's position see that the offeror has in making the offer, has that party bound themselves to their contract. In other words, are they legally obligated in their by making that offer to the contract that or the agreement that they're proposing to the offeree? And if that's the case, we have intent to be bound by the offeror. Now, terms of the offer have to be certain and definite. The certain and definite terms that we're looking for in particular are quantity, time for performance, interested parties or parties, price, and subject matter. In terms of what is predominantly or what is important in the Uniform Commercial Code, it would be quantity, price, and parties, where the common law is very strict. It wants all five of these terms to be certain and definite unless there's an agreement to agree later. Now we look to see, has this offer been communicated to an identified offeree? If that's the case, voila, we have an offer. And if we have an offer now, we need to look to see, has that offer been accepted? And acceptance, remember, is an unequivocal assent to the terms of the offer in the means or mode invited by the offer. And remember that the offeror is master of the offer. As master of the offer, they can set the terms by which that offer can be accepted. I need to add some terms here to look into. When we're dealing with the Uniform Commercial Code, we have some special terms that we're looking at. We look to see whether or not there's been mutual assent. And if we're dealing with the common law, we're looking to see whether or not the mirror image rule would apply. Now, remember, in a mutual assent, we have established that mutual assent is both an offer and an acceptance at the same time. That's why the Uniform Commercial Code looks to this and it says, has there been a meeting of the minds? And under the common law, the mirror image rule, we look to see, has the offer mirrored, or has the acceptance mirrored the method that is given by the offeror being the master of the offer, that the offer can be accepted. So to put that again, to review that, the mutual assent is going to be more with the Uniform Commercial Code aspect, meeting of the minds. The mirror image rule is going to be more consistent with the more consistent with the common law, and it's going to look to see, has the offeree in accepting the offer mirrored the means or the mode upon which the offeror has set the offer to be accepted. Now we're looking to see, has there actually been a unequivocal assent to the terms of the offer through acceptance? Has there been an agreement? An agreement, we talked about this, being a meeting of the minds. Yes, or a I agree would be sufficient sometimes in a writing. Sometimes it would just be the shipment itself, like we have indicated over here under the Uniform Commercial Code. We also look to see under the Uniform Commercial Code a special provision. The Uniform Commercial Code 2-207 looks to see, has there been a battle of the forms between the merchants? Now remember, does that always require two merchants? No, it can actually be a merchant and a non-merchant having observing the Uniform Commercial Code 2-207, but generally between two merchants you're going to have a battle of the forms, and those forms we're going to look to see, are they supplying additional terms? Are they supplying conflicting terms? And if they're additional terms, those terms between two merchants become part of the contract, unless one, the contract itself expressly excludes inclusion of other terms. Two, that additional term would materially alter the agreement. And three, the other party, the party who has not given the additional term, have they objected to that term within a reasonable time. Now remember, I just identified that you can actually have a 2-207 situation between a merchant and non-merchant. In that situation, the additional term would come in at the assent or agreement of the non-merchant. Now remember, if we're dealing with conflicting terms, Then the Battle of Forms Uniform Commercial Code 2-207 will knock out the conflicting terms and gap fill those. The gap fillers are generally course of performance between the parties, course of dealing, and the usage of trade, which is the customs of their industry. Now, we also should look to see, has there been an accommodation shipment? Essentially, an accommodation shipment is a non-conforming shipment that has an accommodation note with it. And in that situation, that non-conforming shipment plus at the same time an accommodation note would act as a counter offer or a proposed counter offer. However, if that non-conforming shipment does not have an accommodation note with it, then it would be an acceptance, yes, but it would also be a breach also. And therefore we need to keep that in mind when we're looking into accommodation shipments. Has there been an accommodation note sent with the non-conforming shipment at the time the non-conforming shipment is received by the offeree? Now we look to see, has the acceptance or has the offer been rejected at the acceptance stage by the offeree? Now remember, rejection just means at the present moment the offeree does not want to accept the offeror's offer, and in that case it does not affect the offer. It just affects at that present moment the offeree's power to accept, at which point they might change their mind and then decide to accept the offer after all. Now let's look to see about termination issues. Termination would actually look more into the offer. We would see, has the offer itself, not merely just an acceptance, but has the offer itself been terminated before acceptance? How would an offer be terminated? Well, death or incapacity of the contracting parties, whether or not there has been a time lapse, and whether or not the subject matter of the contract has been destroyed. And if those things are fitting, then we possibly have a termination of the offer even before acceptance. Now, we also look to see, importantly, has our offer become irrevocable? Because remember, an offer can be revoked until acceptance and or the offer has become irrevocable. Okay? Now, we're looking to see what types of offers or what types of situations would make an offer irrevocable. Well, there's one in particular, and we're going to be looking at it. It's called a merchant's firm offer. And a merchant's firm offer, it's made by a merchant in writing, signed by that merchant, and it's held open by good faith or fair dealing for the time stated or a reasonable time, but neither one of those are to exceed 3 months. Also, we have option contracts. Option contracts are held open with new or additional consideration. Not that the offer has been accepted, but that the offeree has paid new or additional consideration to hold open the offer for a reasonable time. Now, also we're looking to see, has the offeree detrimentally relied to some degree upon the offer, and in that case the offer has become irrevocable. And then we look into see whether or not the type of contract we're dealing with here, a bilateral or unilateral, but a unilateral in the instance we're talking about, a unilateral contract, once that performance has begun, performance of what? The production of custom-made goods. And we're going to be looking to see later on down in our discussion, custom-made goods are different from unique goods. Custom-made goods don't carry with it the one-of-a-kind family heirloom aspect. It is made indeed, or it is simply what we're saying. It's made custom for the particular customer, and that's what the unilateral contract, once performance has begun concerning custom-made goods, would do. It would hold open the offer, make the offer irrevocable for a period of time until such performance has been completed. Because remember, a unilateral contract, once that performance has begun, the offeror should give the offeree a reasonable time to complete performance, because performance by a unilateral contract is the acceptance. Okay, now we're also looking to see about the mailbox rule. In a mailbox rule, where an offer could become irrevocable if, upon proper dispatch, that particular the acceptance would become, the acceptance would not only make the offer accepted, but it would also make the offer irrevocable upon proper dispatch, unless you have a situation where the offeror, as master of the offer, has written out the mailbox rule. But otherwise, the mailbox rule would not only create acceptance, but it would also make the offer irrevocable for a reasonable period of time. Now, down here under consideration, consideration is a bargain for exchange of legal detriment flowing between the offeror and the offeree. Now, the consideration elements, bargain for exchange, we would look to see the actual exchange that is being I should say communicated between the parties or transmitted between the parties, because we have to measure that more like a quality control situation to see if in fact that agreement, the offer acceptance, carries with it sufficient consideration for that agreement to be legally enforceable. Under bargain for exchange, we look to see, is it a gift kind of consideration? If it is, it doesn't carry with it sufficient consideration. Is it a sham or nominal consideration situation? If it is, then there wouldn't be sufficient consideration. And now we switch gears and we go to detrimental reliance, and that's that aspect about requiring someone to perform when they do not have to perform, or prohibiting somebody from performing when they have a right to perform. Now, that would be looking into things like past consideration, trying to suffice for present consideration, which would not work. We're looking to see moral consideration, trying to suffice for present consideration, and again, that would not work. We're looking to see a pre-existing duty rule situation where a duty flowing from a previous contract, the consideration from a previous contract flows into this new contract and tries to make the new contract consideration. That won't work. Why? Because that duty formed from the previous contract pre-existing duty pre-exists the current contract. We need fresh or new consideration in this contract, so that wouldn't work. And then we have outcomes and requirements contracts. The outcome contracts would look to see how the offeror is telling the offeree that they will accept how as much as the offeree outputs, and the output should be made in good faith. Now let's take a look at the requirement type contracts. The requirement contracts is saying from the offeror to the offeree that the offeror will take from the offeree in a contract what the offeror requires. Both of the output from the offeree and what the offeror requires, both of those should be made in good faith to hold open to make the agreement enforceable, because the Uniform Commercial Code will say that even though this looks like there's not sufficient consideration between the parties, the Uniform Commercial Code has said if there's good faith flowing between the parties for the outcome and requirement contract situations, then there would be sufficient consideration even though it looks like there's not. Now, we also look to see, in the event that we don't have sufficient consideration, would there be a consideration substitute? Absolutely. Promissory estoppel. And in promissory estoppel, we're looking to see, has the offeror made a promise? And did they make that promise with the knowledge that the offeree, promisee, would rely, and that was that reliance justifiable reliance? And would it be, to avoid injustice, must that promise be enforced? And if all of those are a yes, then we have promissory estoppel that would suffice for consideration. But remember, it's only when consideration is insufficient would you reach for promissory estoppel, because promissory estoppel is a substitute for consideration. Now, down here under defenses, this is where the defenses against enforceability part of our contract formation kicks in. We look to see the main defense for contracts, the statute of frauds. And we're seeing we're looking into the statute of frauds now, and we're observing that the statute of frauds requires a writing, requires a signature of the party to be charged, and requires all the terms all the necessary terms to be in that writing. Why? In order to prevent fraud from interfering with an otherwise void or otherwise valid and enforceable contract. So to put it a little more basic, the statute of frauds is saying, and in order to avoid fraud from interfering with a contract, they're requiring certain contracts to have a writing, to have that signature of the party to be charged, and to contain necessary terms. What are those types of contracts? Those types of contracts would be contracts concerning marriage, contracts concerning, contracts that by their definition, or I should say by their terms, cannot be completed within a year, the 1 year rule, contracts concerning the sale of an interest in land, executorship contracts, contracts concerning the sale of goods $500 or more, and contracts concerning suretyships. Now, we're also looking to see exceptions. Let's look into the exceptions. What would be the exceptions for the marriage type contracts? Well, that would be mutual agreement between the parties. The exception to the 1 year rule type contracts but that by their terms cannot be completed within 1 year, that would be full or complete performance by one of the parties. The exception for the sale of an interest in land type contracts would be payment of what? Payment of taxes, possession of the land, and improvement of the land. Some people call all this part performance, but you could break it up: payment, possession, improvement, all coupled under part performance. Then you would look to see, is there an exception to the sale of goods $500 or more? Absolutely. That would be goods that are accepted and paid for, goods that once the performance has begun, that let me go back on that. That the exception for the sale of goods $500 or more would be goods that are accepted and paid for. That would be goods that are involved in a unilateral contract once that performance has begun concerning those custom-made goods, and then also the merchant's confirming memorandum, which we're going to be talking about here, and we're going to be talking about the exception concerning the goods, concerning contracts, concerning the contract concerning goods $500 or more, in court admissions. So let me recap that. We would have these exceptions for the statute of frauds requirement that the contracts concerning the sale of goods $500 or more be in writing. If there's these are the exceptions to that. One, it would be goods that are accepted and paid for. Two, unilateral contract situations once the performance of those custom-made goods has occurred. Three, it would be the merchant's confirming memorandum. And four, in-court admissions concerning said goods. Okay, now specifically bringing out merchant's confirming memorandum, let's look at that. That's between two merchants, confirming their agreement, so it has to be in writing, and it would have to contain all necessary terms, and it can't be objected to within a reasonable time or 10 days by the other party. That's in a nutshell what merchant's confirming memorandum is. Now, looking into the other defenses that would work against contract enforcement, we see mistake. Mistake can be mutual mistake or unilateral mistake. Unilateral mistake being that one party is mistaken. Mutual mistake obviously being that both parties are mistaken. In a unilateral mistake situation, unilateral is mistake only when the non-mistaken party, the mistaken party, let me rephrase that. The non-mistaken party knew or should have known of the other party's mistake. So that's the only time unilateral mistake would be a viable defense. Now, under the next defense, we're going to be looking to see undue influence. Undue influence is where where one of the contracting parties is using their family relationship unfairly. They're taking advantage of the other party by using that family relationship to have that other party to make a contract that they would not ordinarily have created. Then we're looking to see the defense of misrepresentation fraud. And this would require the elements of a misrepresentation of a material fact, the knowledge that the other party would rely, the other party does justifiably relies, and there is some harm or pecuniary damage to that party in terms of a contract recovery. Now, we're looking to see about unconscionability now as a defense. Unconscionability breaks up into substantive and procedural, but mainly we're looking to see, does the contract, if enforced, would that shock the conscience of the court, and therefore the contract should not be enforced. That's technically, in a nutshell, what unconscionability is. And then incapacity, this would be the situations involving contracting with a minor, someone who is an infant, someone who cannot make a contract. The only time that these types of contracts would be enforceable would be those concerning necessaries. Remember, enforceable by who? Remember, they can be ratified later, but enforceable by the party who assumed the risk of contracting with the infant / minor, and when they contract with that infant minor, they assume the risk of all the damages and costs that would result therefrom. The only time they can actually enforce those particular types of contracts is in contracts concerning necessaries, food, shelter, clothing, that kind of thing. Now, contracts concerning illegal subject matter would be covered in illegality. Those contracts are at flat not enforceable. Ambiguity, that would involve contracts where the terms of the contract are vague or ambiguous. They're not really certain as to what one party meant, and maybe this might be solved later on. We have the aspect about parole evidence rule, but this might be solved. But at this point, this defense would make the contract unenforceable. And then the defense of ambiguity, the term being ambiguous or vague. Now, duress is where, either for physical or economic reasons, the party's free will ability to create a contract has been halted. Okay, in other words, they would not. What they're arguing is that they would not have ordinarily made the contract, but because of a duress-like situation, due to physical duress or economic duress, they were pushed into that particular contract when they did not want to enter into that contract according to their free will. Now, now we're going to be looking into the next defense of the parole evidence rule. And this is, we're going to actually break this one out further, so we'll just hang on to that one. So at this point, we're looking at contract formation, applicable law, merchants, contract formation proper, look to see whether or not we have a validly enforceable contract situation, or, as what we're going to be talking about now, offer, intent to be bound, certain indefinite terms communicated to an identified offeree, acceptance, accept situations, rejection situations, termination situations, possibly irrevocable offer situations, establishing consideration, benefit of the bargain, and I should say, excuse me, I'm sorry, bargain for exchange. Thank you for your patience. Bargain for exchange, legal detriment. Here, let's see here. There it is. Legal detriment. Thank you again for your patience. And promissory estoppel as being a substitute for consideration. And remember, in promissory estoppel, just as a footnote, you would be able to recover reliance damages. So we keep an eye out for that. Because, remember, we talked about that. There was, in fact, a reliance by the promisee. And then we look to see whether or not defenses, and any of the defenses against enforceability would basically bar enforcement of the contract. Statute of frauds being the chief defense. There's mistake, undue influence, misrepresentation, fraud, unconscionability, incapacity, illegality, ambiguity situations, duress, and the parole evidence rule. Now, going down to third party rights. Third party rights pop up in two particular stages in our contract. Contract formation for third party beneficiary, what we're going to be looking at right here. And in third party beneficiary contracts, the main thing to look into is, was the party, the third party beneficiary, intended to be benefited by the contract? How would we know? Well, the contracting parties contemplated when they made the agreement to benefit that third party. And if let's say they were intended, then we would look to see what kind of intended third party beneficiary are they. If they're not an intended third party beneficiary, but they do get some kind of benefit from the contract, this would be called an incidental third party beneficiary, no enforceable rights whatsoever. But if they are an intended third party beneficiary, what kind of intended third party beneficiary are they? They would either be a donee third party beneficiary or a creditor third party beneficiary. Donee being a gift like benefit, the creditor third party beneficiary would be more of an obligation like benefit. Then remember, before vesting, one of our elements has occurred, the original contracting parties can actually modify the third party beneficiary contract to not have that third party beneficiary be benefited by the contract anymore. However, if vesting occurs before modification, how would a vesting occur? A vesting would occur through learning and assenting of the third party beneficiary contract. 2, materially changing position in reliance upon the third party beneficiary contract. That would be the third party beneficiary detrimentally changing in reliance upon the contract. And 3, that the third party beneficiary has brought suit to enforce their rights. If one of those 3 is present, their rights have vested, and even if the original contracting parties tried to modify the third party beneficiary contract, they cannot modify it at that point and cancel out the third party beneficiary. Now, going now to assignment and delegations, this would be more in the performance stage, where third party beneficiary is more in the formation stage. Now, assignment, remember, assignment is different than assignment of contract. An assignment of a contract is both an assignment of rights and a delegation of duties. The assignment of rights, the assignment proper, is this, that all rights are freely assignable unless if the assignment of the rights would unduly burden the other party. Now, and that's technically it in a nutshell. An assignment of a right would be like the right to receive a benefit of some kind. Now, switching gears to delegation, this would be delegation of what? Delegation of the performance, where there's an assignment. Assignment of what? Assignment of the rights. So now, delegation of the performance, we look to see, is the delegation of the performance creating what would be called as a prospective inability? And oftentimes this does happen. Even though the original contracting party are contracted with let's say the offeree, or we'll say the offeror contracts with the offeree. The original offeror delegates their duty to perform to another party. That delegation would create a prospective inability in the offeree, okay, or the party, the buyer or the seller, because the party is looking at this situation and asking themselves, the party now who is to perform, are they going to perform exactly like the original contracting party would perform? And if not, how do I know if things are going to, in our contract, are going to remain the same as we originally agreed? And that's why when delegation occurs, oftentimes you're going to have a prospective inability, which is then going to in turn trigger a adequate assurance. In other words, the new party to perform should provide now either the buyer or the seller of in our situation adequate assurances that the new party who was delegated performance, that they are indeed going to provide equal performance quality as the original contracting party who delegated their performance. Okay, and that's held in adequate assurance. We look to see if that party has provided not just assurance but an adequate assurance. Now we also see in delegation the type of performance. If we're dealing with a specialized performance by education, skill, or training, those are generally not delegable. And that's why we need to take note of that in our paper. Non-delegable duties include those specialized performances that have education, skill, or training involved in them. And you'll see those oftentimes with like world-renowned, quote unquote, titles, and also you would see like the party is a specialist of some kind in terms of like their field. That would also be a specialist or a specializing situation, or like an artist who is again a world-renowned artist, or someone who is really known in the photography world. That would also be a situation where specialized performance would arise. Now, if that is the case, remember, those would be non-delegable duties, okay? Because it carries with it skill, education, and training that the new party to perform may not have. Now, and then we also look to see, has there been novation? Now, this is a very unique situation here, because if novation hasn't occurred and something happens as a result of the delegation, the original contracting party stands secondarily liable. However, secondarily liable for what? Any kind of damage that would be able to be recoverable. Now, what would happen then? What is the effect of the novation? The novation between the two original contracting parties and the party now who has delegated the performance. If all those parties agree to accept that new party's performance, then there's been a delegation. Then there's been a novation of the delegation. And if that takes place, then the original contracting party is no longer liable to the party who is now receiving performance from the new performer, the third party person in our contract. Okay, so delegation carries. Now let's take a look here under third party rights. Now, third party beneficiaries, we're going to be looking to see intended third party beneficiaries, incidental third party beneficiaries. If intended, are they donee third party beneficiaries? Are they third party beneficiary? Excuse me. Let me restate that. Are they intended donee third party beneficiaries, or are they intended third party creditor beneficiaries? Thank you for your patience. And then we look to see, has there been a modification before vesting? Remember, if vesting comes before modification, the modification is ineffective. Assignment of what? Assignment of rights, freely assignable, and only those rights that would unduly burden the other party are not assignable. We also remember to keep this in mind, an assignment of contracts is both an assignment of rights and a delegation of duty, where assignment of rights by itself is simply that, an assignment of rights. Now, delegation of the performance, we're looking to see, after the delegation of the performance, has there been a prospective inability situation, prospective inability of performance, that has possibly been given adequate assurance by the new performing party to the party who was one of the original contracting parties, and then are the party to receive performance. Then is our delegation of performance a performance that is a specialized performance by education, skill, or training, which would make it a non-delegable duty and non-delegable performance, and has there been novation? And if that's the case, then the party who delegated their performance is no longer secondarily liable. Okay, now we're going to switch gears and go into conditions. And remember, the definition of a condition. A condition is an event not certain to occur, but which must occur for a duty to perform to mature. And we're looking to see the types of conditions, but we also want to take into consideration that we have some what I call issues. Meso meaning in between formation and right before performance. We have two very interesting issues, one being modification and one being the parole evidence rule. Inside of modification, we look to see, are we dealing with a common law contract or are we dealing with a uniform commercial code contract? And if we're dealing with a common law contract, we should be looking to see, has there been new consideration? And if there hasn't, then the modification is ineffective under the common law. But if the uniform commercial code applies to governs our contract and there's been a modification, has there been good faith? Now remember, the new consideration through the common law's requirement for new consideration and the uniform commercial code's requirement for good faith should be, both of those should be coupled with mutual assent of the parties. So it should read something like this, that under modification, the common law would require mutual assent and new consideration, where under the uniform commercial code, it would not only require mutual assent between the parties, but that the parties have modified their agreement in good faith. And that would be essentially what a modification is. Now remember, there's sometimes a hidden statute of frauds issue that I'm just going to make a note of right here. That when an agreement has been modified, that may kick it into that sale of goods $500 or more category, and that's why the statute of frauds would be invoked at this point. And that would definitely demand a header and analysis in your paper. Now, looking to see the parole evidence rule, the parole evidence rule is defined as such that a prior or contemporaneous written or oral agreement, or I should say, a prior communication or contemporaneous communication, written or oral, cannot come into an otherwise integrated agreement to vary that agreement, alter, or change that agreement. So let me summarize that. The parole evidence rule is defined as such that prior or contemporaneous conversations, or some people say evidence, that cannot I'm getting ahead of myself here. Thank you again for your patience. That prior or contemporaneous oral or written communications between the parties cannot come in to vary, alter, or change an otherwise integrated agreement. Okay? Now, and why is that such a big deal? Because the court is essentially guarding the intent of the parties. They're guarding the original contracting intent so that outside evidence, outside communications, the prior or contemporaneous communications, whether written or oral, cannot just come in and change this agreement. And that's why we often put it with a defense inside of our defense, and we also put it here because sometimes it does pop up here as well. Now, remember, how do we know that our agreement is fully integrated? We look to see, has there been a merger clause? In other words, a merger clause in our agreement is going to say this agreement between the parties is the final expression between them, or something along that line. And if that final expression aspect is saying that this contract is fully integrated, and that clause is called a merger clause. And if it's fully integrated, is that where the story ends? Well, not really, because we have exceptions. Also, we want to take into consideration, is our contract or agreement is partially integrated? In other words, there's things that could be supplied in terms of definitions or bringing in terms to define other terms, okay, or to clarify terms. Now, that would make it partially integrated. But let's just say it's partially integrated or fully integrated for that matter. Do we have any exceptions to the parole evidence rule that would allow in evidence that from communications, prior or contemporaneous, that would allow those communications in, even if we have a fully integrated agreement? And yes, we do. Those are the situations involving mistake in what? Mistake in terms. Like, we have a situation where there might be a scrivener's error. There might be a mistake concerning what the parties really meant by one code of any kind, or what did they mean by what did they mean by a specialized term? That would bring in, there would be an opportunity at that point through not only mistake but through ambiguity. Another thing we're going to be talking about here, ambiguity. That part of it, then we'd be able to bring in course of performance, course of dealing, and possibly usage of trade to clarify those particular mistaken terms or ambiguous terms. Vague, in terms of ambiguity, also vague terms would fall into that category as well. So, but remember, in mistake, we also have scrivener's error. In the scrivener's error context for mistake, we're going to be looking to see, can we bring in evidence of what the parties originally intended the, like for instance, price term to be, even though there's an additional zero added on there, that shouldn't have been there. And if that shouldn't have been there, can we reform that agreement to best fit the original contracting intent of the parties? And yes, you can. And then also the vague or ambiguity, just like we talked about, to clear that up. Also, we're going to be establishing whether or not a condition precedent was there or was not there. In other words, a condition precedent would make a performance, it would trigger a performance. If the condition precedent has been satisfied, that duty to perform now is due. And that's why oftentimes establishing that there has been a condition precedent through the parole evidence rule would then put the ball in essence on the other person's court and say, why haven't you performed? I've established not only is there a condition precedent, but that I have established that condition precedent. Now, also remember, we also have defenses. Defenses that would go in here are defenses against enforceability, which are identical to the ones that we have up here. All of these would come down now and fit inside of here as an exception to the parole evidence rule, barring prior or contemporaneous oral written communication in a fully integrated agreement. So that's pretty much it in a nutshell concerning the parole evidence rule. And then now, as we talked about, we're going to switch gears and go into full performance, and we're going to talk about conditions. Inside it, when we talked about the conditions being an event not certain to occur, but which must occur in order for a duty to perform to mature, we look to see what type of conditions are we dealing with here. Express condition, one that was in writing. And if it is, we do not have substantial performance at all. The party must strictly perform according to that express condition. And we also look to see whether time was of the essence and whether or not we have a satisfaction clause. Right here, we're in this time is of the essence. One party is saying that time is a major factor in the contract. Okay, and right here, I think I'll take a break, and we'll make this part here in conditions part 2 of contracts. Thank you so much, and please tune back in to our podcast. And remember, make sure to vote. Remember, my prayer goes out to you, and best of luck on the bar exam.